and welcome to the launch event. And I would like to extend a particularly warm welcome to our distinguished speakers, whom my colleague Dr. Bonura will introduce in due course. This event marks what we hope will be a new chapter in the study of Thai law at SOAS. Now, thanks to Professor Leyland, who's sitting second from the right over there, for a number of years now, our students at SOAS have been able to learn of law in Thailand from his lectures. And more recently, Wirapat Pariyawong, over there, a visiting scholar at the School of Law and the project's coordinator, has also taught some classes on Thai law. But in the history of SOAS, apart from my more recent colleague, Professor Andrew Huxley, who retired in 2012 and who sadly passed away in 2014, and who dabbled in Thai law through the lens of Buddhist law, we really have to go back some 4 decades to 1976, when one Reginald Hugh Hickling, now well known to those acquainted with Malaysian constitutional law, was appointed lecturer of Asian law. Now, if any of my colleagues are here, they may recognize the breadth and depth of his job description. So he was told that the person appointed would be expected to specialize by reference to a region of Asia, brackets China and Japan, Middle East, or South Asia, and to a branch of law, for example, natural resources legislation, commercial law, law and development, and legal process. And he will also be expected to participate in the teaching of common law and comparative subjects within the school's new program of undergraduate legal studies, a very tall order. His initial salary was £6,030 per annum, plus the London allowance of £339. Now, just in case you think that was quite a large sum of money, then as now it compares very badly with other jobs. So one of his referees wrote as follows. He said, "Throughout the time I've known Hickling, he has hankered after a university job. But I fear that until it ceased to be important to him, his salary in the civil service was always much too high for universities to compete." Now, Hickling was at this time 55 years of age. He'd been the Assistant Attorney General in Sarawak, and he'd also been Attorney General in Gibraltar. At the time of his appointment, Hickling had completed his PhD thesis on the history of the codification of law in Thailand, and had published several journal articles on Thai constitutional law and the Thai legal system. From the late 1960s, Hickling had been maritime law advisor to the government of Thailand, and in that capacity he drafted a maritime code for Thailand. Unfortunately for the subject of Thai law at SOAS, Hugh Hickling resigned after 2 years. In 1981, he was reappointed lecturer, but again, he didn't stay very long. It was one of those recognizable love-hate relationships with SOAS. With the launch of this project on rule of law in Thailand, I hope very much that we will lay a foundation upon which any future appointee with interests in Thai law can build his or her teaching and research interests. Some of the activities we have planned for this year include a panel on everyday conceptions and practices of Thai law and social ordering at the conference of ASISUK, and that being the Association of Southeast Asian Studies for the United Kingdom, to be held this September and hosted at the Center of Southeast Asian Studies at SOAS. We will have a series of seminars, some student-focused events, and a working paper series on Thai law. We also hope to be a forum for UK-based PhD and early career researchers working on Thai law. Turning now to this evening, our panel chair this evening is Carlo Bonura. Dr. Bonura teaches Southeast Asian politics at SOAS and his research focuses on the diverse debates over Islamic conceptualizations of civil society and liberalism in Southeast Asia. He is also researching the politics of Malay Muslim communities in southern Thailand. He was previously a research associate at the University of Oxford and loose assistant professor at the University of Puget Sound. Before I hand over the floor to Carlo, I would also like to thank my colleague Dr. Ju San-ju, who is chair of the Center for East Asian Law at the School of Law at SOAS, for allowing this project to be nested within that center. I'd also like to thank Veerapat and our several student volunteers, as well as to Christine Jimpa, one of my faculty office colleagues, for their assistance in organizing this event. So finally, thank you for coming to this event, and I hope to speak to you during the reception.
Thank you, Carol. I'm going to introduce our speakers tonight. Before I do, I want to just say a very few words, just a small number of words, and also provide you with the structure for today's launch. First of all, the project is, the primary aim of the project is to look at the intersection of law, society, and politics at a very critical period in Thai politics. It may appear counterintuitive to some to focus on the rule of law during a sustained period of military rule, and with a government that has been far more aggressive, let's say, than the government that came to power in 2006. However, we believe that this project will allow for a critical space in which to think about a number of different topics, including the role of law in Thai politics and society more generally, the role of the judiciary in Thai politics, the politicization of the judiciary, the question of the constitutional court, and most importantly at this moment, processes of constitutional design. And then finally, more broadly, I think we want to explore, as Carol just mentioned, the relationship between law and the everyday in Thai society. So, having said that, today we will have 3 speakers who will speak for roughly 10 minutes each. Afterwards, we'll have about 5 minutes for the speakers to reply if there are any topics or points that have emerged during somebody's comments. We'd like to facilitate a discussion across the table. And then we will have question and answer period for 30 minutes after the presentations. The question and answer period will be structured along Chatham House rules, which means that you are, what is my understanding of Chatham House rules? That you are not allowed to take, well, for our purposes here, you should not be quoting the names of people, particularly names of people in the audience who make comments or ask questions, and transmit those names outside of this room. So the idea is to create a safe environment in which people can make the kind of comments that they want to make, and in which, and if they'd like to remain anonymous, they can remain anonymous. So first, our first speaker, I'll introduce all 3 speakers at once. Our first speaker is Professor Sir Jeffrey Jowell. Professor Jowell is the founder, director of the Birmingham Center for the Rule of Law.
Bingham Center.
Oh, excuse me. Bingham Center. Sorry. Bingham Center for the Rule of Law. He is Emeritus Professor of Public Law at the University College London. He's co-edited The Changing Constitution, which is now in its 7th edition, and has written 8th edition. Sorry, and has written extensively on the rule of law. Next, we have Professor Peter Leyland. Professor Leyland is an expert in constitutional and administrative law and comparative public law. He is Emeritus Professor at London Metropolitan University and teaches here at SOAS. Professor Leyland has recently authored The Constitution of the United Kingdom, a contextual analysis, and his scholarship on Thai law is focused on administrative justice, constitutional design, and the role of the Constitutional Court. And then our final speaker is Professor Tim Forsyth. Professor Forsyth is an expert in environmental governance, whose research is currently focused on environmental and climate change policy and civil society and governance in Southeast Asia. Professor Forsyth is the Professor of Environment and Development in the Department of International Development at the London School of Economics. In addition to his broad scholarship on environmental governance, he's co-edited Forest Guardians and Forest Destroyers, The Politics of Environmental Knowledge in Northern Thailand. So first I'd like to turn it over to Sir Jeffrey Jowell.
Thank you very much. I've never been to Thailand except en route to Burma, Myanmar, where I have been working recently. But I've always been very interested in the country and I've followed events there. But simply as a layperson, my authority to speak tonight is therefore in some doubt. And it is based, though, on two other factors. First of all, I have read very carefully this brilliant book on the constitutional system of Thailand by Professors Andrew Harding and Peter Leyland, who we have with us now, so he can fill any gaps in the void of my knowledge. And I have run over the last 5 years the Bingham, not Birmingham, Bingham Centre for the Rule of Law, just around the corner here in the British Institute of International and Comparative Law. So I've been thinking a lot about the rule of law for the last 5 years and working all over the world on those issues. Of course, every country is different, and Thailand is particular, as every place is. So what I say about the rule of law in general may not apply to Thailand. But let me begin by raising an issue about the rule of law that is often raised by the so-called rule of law skeptics. And they start off by saying that the rule of law is a vague concept, that it is a contested concept, as is often put by Professor Jeremy Waldron, the professor of jurisprudence at Oxford and at New York University. I mean, he basically sees the rule of law as an ideal, but he regards it as contested. Nobody much can agree around it. And what is it and how does it fit into democracy and human rights? Well, I disagree with that view. And I think that the rule of law is a certain and defined and definite and easy to understand concept. And Lord Bingham, who was our Chief Justice and then the head of our Supreme Court, or the House of Lords as it used to be, probably one of our greatest judges, towards the end of his life, he died in 2010, just as the Bingham Centre was founded in his name, he wrote a wonderful book, if you haven't read it, called The Rule of Law, where he breaks down the rule of law into 8 ingredients, and I normally summarize that under 4 heads. And you'll see what I mean. The problem with the definition of the rule of law is that it has 4 different concepts. Those 4 heads that I'm going to describe briefly in a moment are very different one from the other, but they form a whole when seen together. And during discussion we can perhaps how they relate to human rights and democracy. So what is the rule of law? First of all, the rule of law requires legality. Legality means that we're all under law and not under arbitrary power, the power of a tyrant. We're under law and not man or woman. And this includes the obligation of all public officials who make these decisions about our lives all the time to act within the limits of their conferred powers. They don't have infinite discretionary powers either. So that's legality. The second aspect of the rule of law is certainty. That law should not just change all the time. It should be relatively certain. It may change, of course, but only after fair warning. And this is so that we can all plan our activity and we're not confronted by a law that then is applied retrospectively and you're put in jail perhaps for a law that you didn't know existed or couldn't know existed and perhaps didn't exist before it was applied to you. So there's first of all legality and then there's legal certainty. Now those 2 aspects of the rule of law are the formal aspects. So there are a number of countries that claim they're under the rule of law because they have a rough legality and they have legal certainty. And so China may be one of those countries. And South Africa during the apartheid time, they kept very much to the letter of the law, even though the law was harsh and unjust and discriminatory. And they called them that, they said, well, we're acting under the rule of law as China does. But I call that the rule by law, not the rule of law, because the next two elements of the rule of law are not there. What are those two additional elements? Firstly, equality. That law should be equally applied to the rich and the poor, to the powerful and to the marginalized or the weak. And underlying that notion, there is a deeper level of equality which requires equal concern for everybody's human dignity. And then finally, the fourth element of the rule of law that really brings it to life is what we call loosely access to justice, so that you can actually challenge decisions that are made about you in a fair way. So you have a fair trial and an independent judiciary, which is absolutely crucial. All these different elements therefore make the law. So what's uncertain about that? But there's another objection that's often made to rule of law, and that is that it is a Western concept, or that it only applies to developed societies. And there too, I reject that belief as both wrong and somewhat condescending. And I reject it because I would turn what I've just said on its head. Would anybody in any society want to live in a country that has arbitrary use of power and doesn't therefore follow legality, that has inequality and uncertainty and no opportunity to challenge decisions about your life? Does anybody wish to live in those countries? Doesn't the rule of law apply to everybody anywhere for the reasons that we've been given? And the reasons behind it is that it shifts oppression to equal concern and respect, and it shifts arbitrariness to accountability. And those, to me, are universal benefits for the North, the South, the East, the West, for the rich and the poor. There may be countries, of course, where the rule of law cuts against the grain of the political culture, where authoritarianism is either a preferred way of life for everybody, or is in practice very difficult to dislodge for various reasons. Perhaps contemporary Russia is in that category. Perhaps Hungary, which is moving from what the president of Hungary says recently into an illiberal state. Egypt gave promise for a while, but has now slipped back into a country where an army business elite demand total deference, implemented by a heavy-handed and unaccountable police. But there are other countries that, despite the general pessimism when you listen to the television these days, my grandchildren aren't allowed to listen to the news on television these days. As they say, it's too scary. And it is scary. But there have been some examples of progress towards the rule of law. Sri Lanka may be one of them. Nigeria, after the recent election, perhaps. Burma, Myanmar, certainly. Not quite there yet, but going there. And through the Bingham Center, we've been to Burma a few times and are assisting with its its new constitution. And it was interesting that when Aung San Suu Kyi was elected a member of parliament, she asked, what sort of portfolio might you have as leader of the opposition, was asked by the military rulers, and she said, I would like to form a parliamentary committee on the rule of law and tranquility. And she chaired that, and she noticed that most of the judiciary were unqualified, they were members of the military, and most of the judiciary, she said, were corrupt. How do you get around that? What do you do to build past that or around that? And there are examples of how you deal with the judiciary in post-transitional societies, post-conflict societies. What are the benefits of the rule of law? Well, there are two obvious benefits, and we've recently done a study on this. And the one is, there's a direct benefit. If a country needs foreign investment, there can be, does the rule of law help? Does it help attract investors? On the one hand, you might think that an investor wouldn't go near a country where there was no legal certainty, where the law changed all the time. They could tax you tomorrow where they promised not to tax you before, or where there was no equality and they were treated in a discriminatory way because they're a foreign company, or where property could be taken without compensation. But what we found was that the evidence on that is not actually clear. There's a lot of evidence that foreign investors just go into countries, and if there's a profit to make, they'll make it. They'll get out if property is confiscated, and they hope to make enough profit in the interim period. But we carried out a survey which found the opposite. We interviewed the top Forbes 2000 companies, a sample of 300 of them, and we found that they do indeed consider the rule of law to have been of prime importance in governing their decisions to invest in that country. But as I said, not every country needs that kind of investment. If you look at a country such as Equatorial Guinea in Africa, it happens to be the richest country in Africa, or was before the oil price collapsed, because it's based largely on oil. But then if you look at the question of how the wealth is distributed, all the wealth is kept, virtually all the wealth is kept by a very small elite, and in all other respects, it is found it has the longest dictatorship, longest serving dictatorship in the world. There's a huge amount of child poverty and neglect, and it has the worst distribution of wealth in the world today. I'm just trying to find the figures here. The UNDP estimate that it has the highest proportion of its population living in abject poverty, and when fewer than half its population do not have access to clean water, and where 15% of its children die before the age of 5. So wealth itself is not necessarily connected to the rule of law, and we could provide other examples of countries with a rule of law where there has been a much greater empowerment of the kind of people who need that empowerment through the rule of law, through access to justice, being able to challenge decisions made about their lives, challenge decisions made by the elite to grab all the resources for themselves. So the point I'll make, and I'll stop now because I think I'm overstepping my 10 minutes, is that the rule of law is something that is not vague, it's certain, it's very clear. I believe it to be a universal concept. I think it has huge benefits in terms of accountability. It has benefits for countries that need it in terms of investment, and we've found that. And perhaps most important of all, it has benefits in terms of empowerment. It is an instrument of empowerment for the reasons that I've said and for the reasons we can go into. I can well understand in Thailand how, from the perspective of the present rulers, there is a great temptation to rule in a way that does not allow challenge, that maintains the hierarchical status of wealth and privilege, the hierarchy of status of wealth and privilege. And if that is their will, then the rule of law is not part of their wish list. And we in this country can't be totally complacent about the rule of law either. There have been so many instances we found during the 5 years of the Bingham Center where this government has attacked the rule of law in terms of access to justice, legal aid, try to cut down the opportunity for judicial review of decisions that officials make about our lives, has introduced closed materials, secret proceedings in courts, and so on. So we can't be complacent, and the rule of law is an ideal, and every government will, there's a kind of tendency with every government to try and evade the rule of law if it possibly can. But in all my ignorance, I doubt whether the rule of law is an ideal which the Thai people would reject, the actual people, for reasons I have outlined and because of our common humanity. If we focus on the ordinary individual in any society, we always identify a wish to have respect accorded to their equal dignity, the opportunity to hold the government to account, to challenge decisions made about them with a fair chance of success through a genuinely fair trial before independent judges. And for them, surely the rule of law cannot be seen, at least, as an alien concept. Thank you.
So we've just heard from Sir Geoffrey about the rule of law, and I'm talking about it in relation to the Thai constitution in my presentation. So I've called it Rebuilding the Foundations of the Rule of Law. The nation, Thailand, has developed economically, but of course we've seen, actually over a long period of time, the cycle of democratic rule punctuated by military coups, and it's become all too familiar, and it must be broken in my view. The current omens are not good, and I don't know how a democratic constitution can emerge. I don't have any answers, simple answers, or magic solutions, but when the time does come for resolution, I want to say it will be a political reconciliation. But some of the observations which I have to make to do with the Constitution and to do with the way things are organised are obviously, I think, relevant and may be helpful. I want to again emphasise, and this is where picking up what Sir Geoffrey has just said, that I believe that the rule of law is fundamental to what I would term constitutionalism, as opposed to having a constitution. Because some of the values that we've just heard about are the idea, for example, of seeking to subordinate, and I'm quoting here Harden and Lewis, to subordinate naked power and elevate civil order and rational progress, implicitly rejects the idea of immunity from criticism. It is the central legitimating feature of organised public life, the supreme principle, the rule of law in some ways. And this is, again, to take this point further, Stanley de Smith said, constitutionalism becomes a living reality to the extent that constitutional rules curb arbitrariness of discretion are in fact observed by the wielders of political power. And again, I think this is absolutely telling. So constitutionalism is not about the details, or only about the details. They may be relevant, they may help, but they won't solve the problems. One of the things that's noticeable about the UK Constitution, for all its imperfections, and those that have been arising recently and before, is that there are certain conventions which are recognised by the people that operate the Constitution, by the constitutional actors, and these themselves inhibit certain forms of behaviour. And in a sense, I'm saying that in order for Thai constitutionalism to really start, there need to be a convention that you don't rip up the Constitution every few minutes. But let me just be more specific now. My first area that I want to focus on is the distribution of power, how it's distributed in Thailand. And one of the things that we discovered when we did our study in our book on Thailand and looked into the history, we found out the reason why Thailand has emerged as such a centralised state. Thailand didn't really exist as a nation state until the 19th century, and it was the damn British with their empire and the French on the other side that were impinging upon Thailand, and they were bought off, and the Thais had to make themselves owners of their own territory for the first time. And this was the origins of a very centralised bureaucratic state in Thailand. And what I think about this is that it has a residue to this day. And I don't have time to develop this point, but it means that power is very centralised in Thailand, and that means that in turn, politics is a winner-takes-all politics. It means that if the red shirts win or the yellow shirts win, they are in total control. Now, one of the arguments that we have tried to present is that if you had more devolved institutions in Thailand, I mean, the constitution always says, okay, we're going to devolve more power here and there, but it never does anything in terms of serious devolution of power, then that in turn could affect the way politics actually plays out, because it wouldn't all be a winner and loser type of politics. So that would be one thing. And so I just want to make this point. But it's not that you can just change things in that way. I mean, as far as Thai politics are concerned, we've seen in recent years many attempts to tackle problems of vote buying and that kind of thing. But it's much more difficult to really build a grassroots basic type of politics in Thailand and to get ordinary citizens involved. Now, you know, Thai constitutions have looked progressive in some ways, but for example, they don't endorse the right to organisation, to trade unions and that kind of thing. And so ordinary people are not allowed or not recognised as being able to organise in that way. So I think that's important. There's another way in which this question of power can be looked at, and I think this again is to do with, it's not so much directly to do with the rule of law, but it's the way the law should be framed, and I would describe it as to do with equality of opportunity under a new democratic constitution. The distribution of power and influence across society. I'm involved each year in judging the annual awards for Thai PhD students in London, and I enjoy this task very much, and I'm always incredibly impressed by the amazing achievements of the Thai students involved. And I learn a lot by this because it's all to do with things like medical science reforms, and one was about rotor blades in jet engines or whatever. So there are things which you don't normally know about. But the point that I'm really making is that these technical people who are going in medical science and so on are lapped up in Thailand. But when we look at what happens in terms of public appointments in Thailand, who are the people that are appointed as senior officials, as ombudsmen, as people who are in positions of intermediate and higher influence in terms of the Thai state? It's always retired civil servants, retired generals, and other people of that kind. So this kind of hierarchical gerontocracy, this is something which we don't see addressed at all in the approaches to trying to really reform at a kind of fundamental level the way things go. And I know this is not unproblematic because it also raises questions about a privileged elite, and so I would want to widen this, but I'm just mentioning this as a point. I now move on to the next area, and this is very close to what Professor Jowell was saying, to do with human rights and civil liberties. Of course, I'm echoing what's just been said. The Constitutional Court, under the constitutions of 97 and 2007, was not effective. We need to recognise that. It was essentially captured on a number of occasions in terms of, despite the elaborate appointments processes and other things that went on. And so it didn't really present a formidable obstacle, nor was the Human Rights Commission really effective in Thailand. It didn't have sufficient power and grip, as it were, to deal with these things. But if we're going to move forward in terms of the new constitution, then one of the fundamentals is freedom of expression, the very, as Lord Steyn said, the very lifeblood of democracy, which does not exist at the moment in Thailand and makes it very, very difficult for any form of political engagement to take place. Now, one of the reasons for that, it's not just the law, it's the lèse-majesté law. The lèse-majesté law is totally unacceptable. It undermines freedom of expression, not because it protects the monarchy, which is a perfectly legitimate thing to do, but because of that law. The law is a law of strict liability. That means you don't have to prove that somebody has committed the offence that they're accused of. All you have to do is to accuse them, and they are guilty. If I was appointed as a defender of a person who was accused of the lèse-majesté law, I, the representative, can be accused of lèse-majesté under the law. This is not a fair law. It has been widely criticised, and it is used, this is the worst thing about it, by political, military and other figures to support their position. It's not a neutral law, it's a law which is manipulated and nobody has a defence, and it involves disproportionate punishment. Again, offending against the rule of law, you are sent for a minimum of 3 years imprisonment. No question about it. That is the minimum. 15 years is the maximum. It has to go. This law, together with the Computer Crimes Act, has been used to severely restrict freedom of speech in the modern internet age, and it means that people are not able to use the social media in a way that would be expected in any free society. So this sets the background for the way that the present constitution, the idea that there's a debate going on, is completely nullified by these laws. Now, moving on, in things that the constitution has not done in the past, what about the link between television broadcasting and the military controlling television channels? Again, totally unacceptable in terms of conflict of interest and so on. So, and the other thing I would like to see, looking back at the record of the last 10 years as far as the Constitution is concerned, is rejigging at constitutional level the right to demonstrate. Because demonstrations, kind of rent-a-mob demonstrations, have been used to undermine the entire constitutional system by prolonged demonstrations sponsored by powerful individuals. And this is, again, a way of undermining democracy. Okay, people should have the right to demonstrate, but there needs to be, and this reminds me of the Public Order Acts which were brought in the United Kingdom during the time of the fascist marches in the East End of London in the 1930s. We have certain rules which restrict the right to demonstrate as a response to that. So that's my next point. Now I'm coming to the end. I know that the time is limited. So going back to what I said earlier, I think access to constitutional justice and the way the Constitution works in terms of providing remedies is obviously going to be very important in any future constitution. I just want to, in my closing few remarks, say something about what's going on at the moment in terms of the Constitution, because what I've been saying are just general points. They're not related to this particular process. There's been prevarication and delay by the present government. The drafting committee, which is presently chaired by Michai, faces the charge that it represents the same elite and that it lacks legitimacy as it was set up by the junta. The process of drafting is taking place against a background of extreme repression. The latest proposed versions have even more voluminous detail. I've been looking through and scrolling through on my computer. It took me I thought, God, they've added more and more sections to this constitution. It's going to be the world record longest constitution, beating India, which has a very long constitution. And I was thinking, oh my God, what am I going to do when we do the next edition of the book? But anyway, I don't think it's going to last very long, because it's the latest proposed version have been, that they have, a lot of the things have been pasted and cut from other constitutions, including emphasis on anti-corruption and watchdog bodies and so on. But all of this, of course, is subject to big qualifications. It allows the generals to take back absolute power at any time in the name of national security. That's not a constitution. I mean, this is a joke. And it introduces more challenges in terms of making constitutional amendments, which means that the argument is that you'd be lumbered with it longer. But my argument would be that the Constitution is going to find it very difficult to get through a hurdle of a referendum as a result of this. So there's no sign that the new Constitution will de facto hand over power in a serious way. It's essential to break the mould which has seen this cycle of the military taking over and at the same time indemnifying themselves from any responsibility or liability. It seems to me incredibly ironic that an ex-elected Prime Minister is facing prosecution which relates to the policy followed by her government, allegedly failing to prevent alleged corruption associated with the rice subsidy. Corruption is bandied about in Thailand as a word used without proper definition in context. In consequence, there are flagrant double standards, disproportionate punishment and things like this. The very powerful and rich always seem to escape justice. In other words, there has been an absence of the rule of law values at the top. Constitutionalism, and I'm quoting from what I said earlier, becomes a living reality to the extent that the constitutional rules curb arbitrariness of discretion and are in fact observed by the wielders of political power, and that allow also significant room for the enjoyment of liberty for the combined citizenry. That's my presentation. Thank you.
Okay, hi. Now, I'm approaching this discussion tonight as somebody who's not a legal expert. By the way, I'm not from Thailand either, which makes me somewhat nervous about talking about a country where I'm not actually from. Although I was just realizing just now, but it's 29 years since I was first in Thailand, which makes me feel rather old. And I've been back many times, and I've also spent some time there as a journalist, working in Bangkok and elsewhere. What I'm trying to do today is not so much to talk about the constitutional issues, I think our other panelists have done that expertly, but instead to talk more about the broader social changes which might make constitutional change important in other ways. So in particular, Sir Geoffrey has listed the three aspects of rule of law as being legality, equality, and access to justice. Now my point as a social scientist, as a political scientist, is to say that this is great, but it depends on how it works in practice. And what I'm arguing is that it's much easier for people to access legality, equality, and access to justice if they act in accordance with cultural codes or with expectations or roles which are prepared for them. And that's what I'm trying to do tonight, which is to look at how far those roles evolve or do not evolve, and how far those things might actually be arenas for democratization and equality, which might coexist alongside all the crucial other changes happening in terms of constitution. Now, I'm going to show you some images, which I hope will illustrate what I'm talking about, and to say that the obvious points that so many people talk about in terms of Thai democracy are the well-known tragic events such as October 1973, and of course October 1976, which are often considered to be the high watermarks, if you like, of democratic crisis, the urgency of military rule, hopelessness of democratic outbursts, very much set the flavour for the last 25 years. But what a number of Thai critics have said, people here may or may not agree with these critics, is that Thailand has lost its way. And just one of those critics is a man who has developed parodies of these sorts of terrible images. This is his parody here. This is Manit Sriwanitpum, who is also known as the Pink Man, who develops these very critical takes on classic images in Thai politics to give the impression, or to argue, that basically Thailand has become a superficial commercial society that has lost its connection to the deep issues of politics which have affected them in the past. Now, what I'm trying to say here tonight is what else might have become assumed over the last 30 years. Which ways is democratization enhancing, such as all this debate about constitution, but in which ways is it actually hidden, in ways which might actually create roles for people to act in accordance with constitutional change, which actually may not be democratic at all. So my questions are, as the Pink Man is asking, what has happened to Thailand, what have they forgotten? Which social divisions persist despite all this discussion about politics? What rules of democratization lie outside of the law? But also, in particular, the 1997 Constitution is often considered to be the sort of high watermark of public inclusion. And now we're sort of backtracking away from that. But I'm also asking, how far does the actual 1997 Constitution actually deal with these deeper questions of democratization? Now, I'm mentioning the 1997 Constitution partly because it made a particular role for public participation in infrastructure and environmental projects. It was very much to do with community forestry at the time, for example, or the creation of dams, which have become very much test areas for democratization, which, as Peter has argued, the Constitution might be a source of remedies for. But what I'm actually asking is how far are social trends limiting the ability for constitutions to provide those remedies. So to show some of the images again, I would suggest that there are two sides to public activism. This is a famous image from the Assembly of the Poor, which is a coalition of NGOs and trade unions, largely in the 1990s, which was very much the if you like, the poor person's vehicle for democracy in the 1990s. And this image, I think, shows very much a sort of flavour of the AOP, the Assembly of the Poor, by basically showing people coming together in this very sort of Maoist sort of image of, the people power, we will search for democracy. But at the same time, whilst this is going on, there's also another side to all of this activism, which is this demonstration of piety, humility, and appropriate behaviour within a Thai society. Now, this is partly a Buddhist thing, but I think it's more than a Buddhist thing. I think it's more of a sort of a hierarchical social class thing, which is that basically the lower classes are expected to act in certain ways, and if they don't act in those ways, their behaviour becomes illegitimate and therefore less powerful. Now, this image is one which occurs all the time. The top photograph is actually from the red shirts, very recently. The lower image is a picture I took in the Bakmun dispute, which is a dam which was built in the far east of Thailand near Cambodia, where the Assembly of the Poor created this village of the poor. And in this case, this is the Mahawitilai Konjong, this is the University of the Poor, which was part of the village of the poor. And again, you get this image of the hands together, which is partly a Buddhist image, but also, I think, as a symbol of poverty and appropriate behaviour, which recurs in so many different ways. So these are just other images. One, the poster, is from the Royal Forest Department, which is talking about how planting trees is not just an ecological thing, but it's part of the duty of honouring the royal proclamations. This is the symbol above the hands, is actually the symbol of the royal family. I think that's the one of the king. Where basically planting the trees is also offering piety towards the Thai establishment. But also on that mural, which is painted on the side of a school in Bangkok, which has now disappeared, again, the same thing. It's like this idea that amongst all this terrible environmental problems going on in Bangkok, the hope remains, put your hands together, plant a tree in the water, and the colours will come back. Now, what I'm trying to say here is that this is a quick way of talking about social roles. Another way of talking about this is in the doctrine of sufficiency economy, which the king has been proclaiming for some years now. And in particular, it became very prominent about 10 or 15 years ago. And this skyscraper in La Prao in Bangkok shows, in one side it's in English, on the other side it's in Thai. It's essentially this idea of portraying sufficiency economy as an appropriate way of behaving. Now, I'm not suggesting that all political activism is controlled by sufficiency economy, but I'm putting it up there as yet another way in which this is actually portrayed as appropriate ways to conduct democratization. And the essence of sufficiency economy is that people should focus more upon sufficiency and appropriate behavior under a time when many people are worried that Thailand is consumed by greed or by personal competition in ways which are against the essence of Thai society. But the critics of sufficiency economy suggest that actually this is being used to create a role for the poorer people, which is traditional and somewhat romantic, in which people follow an appropriate role of living in villages and living in balance with nature, rather than actually rising up and challenging the status quo, or what Peter referred to as the hierarchical gerontocracy. And just to build a bit more on this image in La Prao, this is what it looks like from a different angle, and I'm saying this is symbolic of a very persistent image of what is appropriate and what is not, and the extent to which people getting on with their lives look up and believe that this is the way that they have to act. So this is a very powerful way of behaving. And I think this is reflected in a couple of ways, which I'm now going to discuss, which is the need to be democratic and to engage in activism, but also to abide by certain codes. So just to use one image from the 1990s, this is from Chiang Mai. Here we have villagers standing up, talking about the need to make land claims in a communal way, that it's all, the images at the front are all to do with Maoism, the idea of the turbans as well, the idea of protest and democracy, people coming together. But in the background, you have an ordained tree with a saffron robe wrapped around it, which gives it the aura of tradition and respectability. Now, this is important because I think it still goes on in contemporary ways. So I was in Phrae province in the north of Thailand a few years ago, where I was fascinated to see that the protests against the dam, so in 2011, Bangkok had huge floods. The Pheu Thai party, especially with the Deputy Prime Minister Prod Prasop, who was previously the head of the Forest Department, was promoting dams as a solution to the floods problem, and was therefore reinvigorating old proposals to build dams in the rural areas when the rural people didn't like that, they wanted to protest. Now, under the 1997 constitution, they had the right to participate in these sorts of projects. Under the current proposals, they probably do not. But how do they actually respond? Well, they responded by trying to show that they were neither red nor green, so here we have lovely red and yellow merged together, but also trying to represent this in the sense of tradition and poverty and victimhood, the idea very much of sufficiency economy, the idea that you just get on with your lives, we're just the poor villagers, please don't hurt us, we're acting appropriately. And they organised various disputes, including the ordination of the teak trees in the local forest. Now, I don't think the teak forest as such was threatened by the dam, but nonetheless they wanted to use this as a symbol of their appropriate behaviour, and trees and forests is an important threatened thing in Thailand, so therefore they wanted to sort of resonate with those parallel concerns as well as simply oppose the dam. And it's led to this sort of images which were all done in front of the cameras, and the various newspapers reported on this. Now, my point here is to say all of this suggests a certain way of behaving as appropriate, regardless of constitutional change. And I'm saying that the threat to the 1997 Constitution, which gives a right to people to participate in these decisions, is leading to this democratic response, which is actually shaped by preordained roles of what is appropriate and what isn't. Now, this also relates to the second thing I want to talk about, which is the role of rice farmers. Now, we've already discussed the rice purchasing deal, which was, I think, fair to say, was a populist attempt by the Thai government to basically buy out the rice farmers as a demographic force in general elections. But during the arguments about the legitimacy of the rice deal, the rice farmers activated, again by pressing the same button. So they had this huge procession upon Bangkok, which represented images of poverty and tradition, all these little carts coming together. But also this interface between tradition but also anger, which I think sounds very similar to what happened before. Which is also interesting because despite the rice farmers voting for red parties in the past, what was also interesting at the same time was the extent to which the yellows began to court the rice farmers as their allies. Now, on a cynical interest-based point of view, this was simply because the rice farmers were thinking like, right, who can we get the best deal from? The reds, who look threatened, or the yellows, who look like they're going to take over? But also, at the same time, I'm arguing that the yellows wanted to appear appropriate by cultivating the image of that they are the friends of the rice farmers. They wanted to understand their pain. They wanted to represent them as poor victims of this corrupt government. So in the yellow shirt camp in Lumpini in central Bangkok, you suddenly get this procession of people wearing T-shirts or selling T-shirts, trying to ally with the rice farmers as victims and as poor. So the image of a skeleton holding the sickle, Chao Na, rice farmers, yeah, people of the rice fields. And the black T-shirt shows Mare Prosop, who's the goddess of the rice fields, and then the T-shirt statement at the end is basically saying that rice farmers deserve a better deal because they are, they're the people in charge of the land and, they know what they're doing, that sort of essence. All I think here is an interesting shift of alliances which show how far the codes of conduct behave, but also how far the hierarchies keep on reproducing themselves regardless of constitutional change. So my final picture is this one, which I think is an extraordinary image of this lovely woman who gave me her permission to take this photograph. Middle class Bangkok citizen, clearly in the yellow camp because she agrees with the yellow. She's got a phone holder in yellow, wearing the Rice is Life T-shirt, which I'm trying to suggest here indicates the limitations upon constitutional change as a source of remedies. What I'm suggesting here is that you get this alliance of elites who are trying to cultivate allies amongst the poorer classes by both sides reproducing this image of hierarchy and victimhood, which maintains a social order rather than actually changes the social order. And both of them are buying into it because they both see political opportunities. But ultimately, these are the things I'm arguing hold up democratic change in Thailand, which coexist alongside the questions of legality, equality, and access to justice, which you might get through constitutional change. Thank you.
Wonderful. Three very interesting presentations, certainly a lot to think about. We have three questions that have been submitted to us by the one from the Bangkok Post and two from Panchatai that I'm going to pose to the panel. So the first question is, the Bangkok Post asks, the military junta often refers to Thai democracy as Thai-style democracy. Is there a way for Thailand's Thai-style democracy to adopt the rule of law used in other Western democratic countries? Why or why not? And just to, so Jeffrey, just to ensure your, just to include you thoroughly, directly in this answer, perhaps you could also address some of the points you talked about with regard to rule of law being a universal, and perhaps culturalist claims in certain countries as to whether or not that would be appropriate. So, who would like to go first? Is it possible for?
Do you want to go?
Right, certainly. Are there more than one model of the rule of law? I think we've got to break this down into two parts. First of all, the essence of the rule of law, and secondly, the means to achieve the rule of law. I believe that the essence of the rule of law is certain and universal. There is no rule of law where there is arbitrary power. There is no rule of law where there is retrospective punishments and constant changes without fair warning. There is no rule of law where there is unequal application of the law, or where there is excessive corruption so that people can buy access to benefits. There is no rule of law where people cannot challenge decisions made about their lives through a fair trial with an independent judiciary or other means of dispute resolution, such as ombudsman and so on. So that's the essence of the rule of law, and I don't believe that there is a Western or Eastern or Northern or Southern or Thai or British or Chinese or African concept of the rule of law which doesn't contain all those features, that leaves any of them out, because they all make up a whole. However, there are different ways of achieving that, and there's a different time scale also to achieve it. Some countries have to move towards the rule of law, which I said is an ideal that is not fully achieved in any country, including this country. So there are different ways of appointing judges, for example, through judicial appointment commissions or by the executive. And both those ways, the American way, for example, of appointing judges is by the president submitting a name to the Senate, and you get political vetting through a confirmation process. Here we used to do it through secret soundings by the Lord Chancellor, taps on shoulders to people who might be judges. Now we do it by an impartial Judicial Appointments Commission, and that's being done increasingly throughout the British Commonwealth. So how you get there, and the pace at which you achieve it in certain countries, because of the problems of those countries, is certainly a possibility of difference. There are possibility of differences, and of course the rule of law, in order properly to hold, to bite, to have traction, must rest in a soil in which it will remain. It can't simply be transplanted. It is the culture that has to embrace it and keep it. So there are elements of relativism, but the concept of the whole is an absolute one.
Good, Peter. Do you want to?
Yes, I'd just like to say I've really tried to answer this question in a different sort of way by saying that I would just echo what Geoffrey has said, but add to it that the problem in Thailand has been, as I said towards the end of my presentation, that the idea that you can press the reset button on the constitution and that the military can take over or whatever, that they're indemnified from anything that goes wrong. The idea that people who have abused power are not subject properly to the rule of law, these things to me seem fundamental to Thailand, as they do to any country. And the idea that Thai particularism can sort of defend those sorts of practices, or not those sort of practices, but just be a kind of justification for the status quo, which I think this is what I interpret this as, that the present regime is just defending the status quo as it is and saying that's the Thai way of doing things. It's not that Thais have been able to vote on that. They haven't been able to be consulted or whatever on having the kind of rule they have at the moment. And for that reason, I would say that it's very difficult to know what can possibly be meant by this kind of Thai approach, except that the current establishment view rules okay under all circumstances. That's my interpretation of this, and that's the Thai way of doing things. No, it's not. I mean, if you look at it historically, if you go back 100 years and you see what was happening under different systems of law in Thailand, it wasn't like it was today. Thailand has evolved like all other nations, and it continues to evolve. And as it evolves, I'm sure that the Thais will choose their own form of law. But my argument would be that that has to be chosen more widely, not according to how they're dictated to by a narrow elite.
Wonderful, good.
I'm happy to talk. Is it appropriate for me to talk, given that I'm not the legal expert in the questions about law? I mean,
No, of course.
well, I would just echo what the other experts have said, which is the rule of law requires, it isn't just simply having a law. You've got to have access to justice, equality, and legality. You've got to have the ability to trust in the system. And as Peter's just said, you can't really have trust in the system when you have an elite who want to change a law to make sure that they're not, affected by the law. So until that actually happens, then technically speaking, rule of law is impossible. So in theory, it is possible, of course, in Thailand, but you have to have significant shifts to make sure that there really is a movement towards a trusted and accessible legal system.
Excellent. Prachata's first question, I must admit, is rather lengthy, so I'm going to take the liberty to summarize it. I think they're interested in the way in which the military justified the coup in 2014 with regard to the way in which the polarization that had structured Thai politics was, I'm sure in their minds, getting out of hand, that these lengthy mass mobilizations that Bangkok had experienced since November of 2013 required some type of return to order. And their first question has already to some degree been addressed, but their first question is the rule of law ever consistent with military rule? And I guess the question behind this is there ever an excuse for exceptional rule in the name of preserving, in the name of some type of political intervention, preserving political order or social stability?
Well, the answer is that there is always an exception to most human rights in particular. Not all of them. For example, if things really got out of hand in terms of terrorism in this country, if the situation were of such, the emergency was of such a nation that it was absolutely necessary to suspend the right to a fair trial by, for example, allowing detention without trial for 28 days, 40 days, 60 days, then the courts would allow it if the intervention was proportionate to the emergency involved. In other words, you don't have total power to say, forevermore we're not going to allow this, or for 10 years, or we're going to suspend Parliament, but you can take necessary measures to preserve law and order. I think every society allows that. There are certain limits to that. For example, some societies, many societies would say never to allow torture. Others would say perhaps a degree of torture. So there, I think it is possible to argue that there is a degree of possibility for the suspension of human rights, civil liberties, and the rule of law in certain circumstances. But that suspension should not be an excuse for continuing arbitrary control of power for an indefinite period, and there should be constant reviews to see if the emergency might be over or if some of the measures can be relaxed. And there is a depth to which those measures should not be allowed to fall.
I mean, I'd just like to add to that I understand where the question's coming from, because this is not to do with law and the constitution, but it's to do with one's knowledge of what was going on in Thailand and Thai politics. The fact was that the government of the day at the time that the coup took place was confronted obviously by these demonstrations, and they were not in a position to control the forces of law and order and so on in the way that governments might otherwise do. So you didn't have a situation. This is to do with my point that I was trying to make about the idea that a constitution relies on the actors who are responsible for making it work, performing their appropriate role. And the fact is that because of the deal that had been done to allow the government at the time, the red shirt government, to rule, it was subject to the fact that they were not really in full control, and it meant that you had a government in name, but not a government that was able to do these things, and therefore the rule of law and all of the other things that the government would need to be able to muster the forces to control such things were not at its fingertips, and so everything sort of broke down. Now my point is that what a solution in Thailand, even if it's a partial solution, needs to be adopted by all the people who are going to be subject to it, red, yellow, green, whatever they happen to be. And until that situation is reached, the constitution won't really work. But I would just agree with what Jeffrey said, that a military solution could only be justified in the interim. It's not in emergency circumstances. It cannot be seen as a solution at all.
Good.
Well, I feel poorly equipped to add to the eminent speakers before, but if I could put it simply to say that if there is an obvious crisis, then whatever has to intervene to deal with that has to be seen to be trusted and fair. You know, one can think of examples, Second World War in Britain, for example, you know, national government, people trusted it because of the circumstances. You know, what's going on in Thailand, I think, is proving to be not trusted and not creating the sense of open opportunity, which people would want to have in order for a full definition of rule of law to take place.
And then the second question that they suggested, which actually was directed to you, is what are their question was related to the social conditions that would allow for reconciliation in Thailand, but perhaps we could expand that and include both the social and the political conditions. And again, Sir Jeffrey, you mentioned the way in which rule of law can be empowering, so perhaps if we can think about environments in which we're not only talking about the social and political conditions for reconciliation within Thailand, but also other ways in which the rule of law could be linked to political empowerment. So, would you like to take the first shot at it?
Well, the question is the social conditions for reconciliation. The obvious question is between who? I'm assuming it's a rather old question in the sense of reconciliation between red shirts and yellow shirts, or between possibly the people who felt harshly treated under the repression of the red shirts, and possibly those who felt that the yellow shirts got away with murder when they occupied the airports and nobody was prosecuted.
They also mentioned social divisions, so the social divisions that are structuring Thailand more generally.
Okay, so I find it hard to answer that question except in very general terms, which is that a trusted process of policy making and decision making. The challenge is that one has to reach a situation where decisions are made in a way that people are happy to believe in things. I could say the difficulty from my perspective, which might not be an accurate perspective, is that it's a complicated situation. There are many analysts, I think the BBC, for example, do this a lot, which tend to represent the Thai problem as simply a problem of rich elites in Bangkok not willing to listen to the poorer masses who are demographically more powerful than them. I think that's way too simplistic. I think the situation is complicated by the existence of Thaksin, who initially might have been a revolutionary kind of leader, but then I think the evidence of him serving his own interests above national interests became too much to deny. But that situation led to a problem in which many of the shall we say, poorer people got onto the red shirt bandwagon, partly using Thaksin as a symbol, where the issue of is Thaksin good or bad began to occlude whether actually there is reconciliation happening or not. And what I think really has to happen is a movement towards a more fairer and representative form of decision making, which makes people feel listened to and therefore included, which isn't necessarily co-opted by questions such as was Thaksin interfering with the succession process or not. I think that all of those issues, important as they are, whether they're true or not, need to be seen as a rather like a smokescreen, which lie on top of the deeper, longer-term transitions in Thailand, which is that the old forms of governance don't really work in a 21st century Thailand.
Good. Peter?
Well, I will just make a limited contribution here just by saying that I feel that the needs for a new constitution to have legitimacy, it would help enormously if there was wider consultation and participation in the process, and that was expressed in the way the constitution was actually drafted. That's, to me, what made my interest in Thailand start, the 97 constitution, because that did have this element to it which made it extremely attractive from the point of view of a kind of democratic way forward, and I would just think that it's, you know, it's not too late to have another go, and that would be my view, looking at it from the point of view of constitutional and legal solutions. That's it.
Wonderful. Go.
Yes. In constitutions in which I've been involved, such as South Africa, some of the Caribbean constitutions and so on, they've only really worked. They're only there to stay if the people feel that they've bought into the constitution. And in South Africa, there were discussions up and down the country. In other countries, there have been television programs during the constitution-making process. There have been constitution conventions. If constitutions are imposed from the top down, they often fall apart because the people don't feel any legitimacy, any buy-in, any part of it. Sort of ownership is required. And then, a part of that, there has to be a sort of an understanding at some point that there has to be a coming together, as there was in South Africa. And Nelson Mandela was wonderful about that in the sense that there was a cry for revenge. There was a huge move that they wouldn't even have a Bill of Rights in future because that would be, quote, a bill for whites. In other words, whites would insist on their property rights, and wouldn't permit redistribution of land and so on. But in the end, it was decided that the problem in South Africa wasn't only segregation, apartheid, but it was also tyranny, and therefore there should be rights that even controlled this new government. That realization allowed for all sorts of reconciliation processes that you've seen in countries like Chile, South Africa. Nepal at the moment are wondering about this question. Should there just be vengeance and bloodletting? Should the bad old guys be prosecuted, or should there be an immunity which would allow the old people in, the bad old guys, to come into the process and be part of it, and then everybody would feel that there was a new beginning. So there are different models from which to choose about race. Some have worked, some haven't. But that's the kind of exercise that needs to be done.